I should make some disclosure myself. As you may know, my firm represented Meletios Apostolides in the recent Court of Appeal case and the European Court of Justice case, where we succeeded in upholding some very important property rights, rights of Mr. Apostolides in relation to the occupied areas in relation to his property. I wanted to say that the views I'm going to put across tonight are my own personal views. They're not the views of my firm or of Mr. Apostolides or my good friend Costas Frangeskides, who introduced the case to the firm, which was run by a team led by one of my partners, Simon Condon. Now, I think we're up and running. Excellent. I'm going to give you the more practical talk tonight. Being a practicing lawyer, really what I want to do is take the rule of law and take what Glaucos has explained and put forward a case study. And the case study we have is the Cyprus issue, of course. And at the core, and I was just thinking as I was listening to Glaucos, what is the issue? What is the real issue? And what do I want to talk about tonight? It's the comment that I've faced many times when people talk about the cases I've run. Another disclosure I should make is my father is from occupied Limnia and Varosi. It's the comment that's often made to me, which is that you can't solve the Cyprus issue by legal means. It's only going to be solved through political means. And what I want to do tonight is I want to explain how the rule of law in relation to the Cyprus issue must be upheld, has been upheld, and mustn't be forgotten, and we mustn't be frightened of it. Because sometimes we seem to be very frightened of standing up and saying, what are our rights, and why should we uphold those rights? Now, I put some questions up, and these are the questions I want you to have. This is the case study. This is really what we want to be looking at. Has the rule of law been upheld in relation to the Cyprus issue? Or have its core principles been diluted? Has the rule of law upheld the sovereignty and jurisdiction of the Republic of Cyprus, the rights of the citizens of the Republic of Cyprus, the obligations, being British, I'm very concerned about the obligations of my country back home in the UK towards the Republic of Cyprus. And to answer all those questions and use the Cyprus issue as a case study, because I want to answer that point, which often comes up. Don't use legal means. We can only go through the political process. But why do we have the legal process? It's there for a reason. It's there for all the reasons that Glaucos just explained, and we mustn't forget that. And I'm basically structuring my talk in, you'll be happy to hear that I'm not going to spend as much time defining the rule of law. I will define the rule of law briefly. I will look at it in relation to the English and EU legal context. I will then look at some international law provisions as they apply to the Cyprus issue. I'm going to look at it from the point of view of the UK under English law, and that's how the Apostolides case was decided in the courts of the UK, in the courts of England, in the Court of Appeal, but also the European Court of Justice. Then I will of course look at the Apostolides case, and I will conclude. Again, I'm not going to repeat what Glaucos said. I do like the John Locke definition, wherever the law ends, tyranny begins. I've also quoted Thomas Paine, one of the founding fathers of the United States of America, the US Constitution, that in America the law is king, for as in absolute governments, the king is law, so in free countries the law ought to be king and there ought to be no other. Now, again, some definitions. I think I won't dwell on these tonight. I'll get to the core. Obviously, the rule of law usually implies that politicians and officials must have legitimate foundations based on authority conferred by law, the independence of the judiciary, and that the state should not be able to interfere with the rights and liberties of individuals other than in extreme situations. Now, again, going back to something that Glaucos mentioned, there are some jurists and legal philosophers who obviously say the ultimate rule of law has no substantive content. Say you have a dictatorship, a non-democratic legal system, that's probably the most effective rule of law. However, the rule of just law, in an open liberal democracy of course, must afford adequate protection for fundamental human rights. I mean, that's at the core of the rule of law in our constitution in the UK and in the EU. And of course, all of this is reinforced by the preamble to the Universal Declaration of Human Rights, which states that it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. The European Court of Human Rights again refers to the rule of law as being the notion from which the whole convention draws its inspiration. Look at it in English context. I want to reinforce this because it's very important as background as to why the rule of law is so significant when we discuss the Cyprus issue and what the political powers that be try and sideline it, and I want to bring it back to the fore again. Lord Hope, in a case in 2005, it is no longer right to say that Parliament's freedom to legislate admits of no qualification whatever. The rule of law enforced by the courts is the ultimate controlling factor on which our constitution is based. And then a very important act, 2005 Act, which for the first time enshrined the principle of the independence of the judiciary in the United Kingdom, also clearly says the Act does not adversely affect the existing constitutional principle of the rule of law. Again, in an EU context, this is the Labour case from 1986, judicial recognition, the EU is a community based on the rule of law. So that's the EU context. Legislative recognition in the EU. The Treaty of the European Union. The European Union, is founded on the principles of liberty, democracy, respect for human rights and fundamental freedoms and the rule of law. Principles which are common to the member states. Even going as far as Article 49, which demands that prospective members respect the rule of law. And there's one particular prospective member we're well aware of at the moment who would like to become an EU member. We might want to remind them about that now and then. Article 7, as amended by the Treaty of Nice, allows for the suspension of existing members in the event of its breach. So again, we must remember all this. This is basic law, if I can put it like that, which is often forgotten, often sidelined. Now, again, this is a case study, the Cyprus issue. When looking at the Cyprus issue, we have to assess whether and how international treaties and obligations become part of domestic law. And that really is what is called the customary international law, which I'll put a definition up there. And the reason I just want to describe that is I'm nextly going to go into UN Security Council regulations. I want to go through those with you. I want to go through the UK's obligations. I see some of the British High Commissioner here tonight. And the UK's obligations, again, which the UK purports to support, it is bound by. You must remember the UK is bound by certain obligations under the Treaty of Guarantee through what is called customary international law. Customary international law are laws which derive their authority from the consistent and constant practice of states, rather than from formal expression of the treaty or legal text. And as Lord Bingham said in 2006, customary international law is part of the domestic law of England and Wales. Now, again, this is all background. When considering as a case study whether or not the rule of law has been upheld in relation to the Cyprus issue. And as you can see at the end of this call, you can probably preempt what I'm going to conclude with. I'm going to say it has been upheld, particularly because of the recent decision in the Apostolides case, and I'll take you through some of its core decisions. But let's start with the Security Council resolutions. Let's remind ourselves of the Security Council resolutions. They create obligations that are legally binding on the United Kingdom. There is a legal obligation asserted in the United Nations Security Council resolutions not to recognise the TRNC. Now, a United Nations resolution, I'm sure you will remember, are usually put on the basis that they urge states to take certain actions, or they call upon states to take certain actions. But they can also state what the law is. And here, let's take as an example, Resolution 541. 1983, the United Nations Security Council deplores the declaration of the Turkish Cypriot authorities of the purported secession of part of the Republic of Cyprus. It considers the declaration as legally invalid. That's the law. The United Kingdom is bound by that. It calls upon all states to respect the sovereignty, independence, territorial integrity and non-alignment of the Republic of Cyprus. It calls upon all states not to recognise any Cypriot state other than the Republic of Cyprus. And you're probably all familiar with these resolutions. But I want to remind everyone they're legally binding on the United Kingdom. And I mentioned Resolution 550 there as well. And let's remind ourselves of the Treaty of Guarantee. Two treaties and the Treaty of Establishment, signed by, of course, UK, Greece and Turkey. The UK, again, is bound by its terms. The Treaty of Establishment delineates the territory of the Republic of Cyprus. Sorry about that, I think there was a bug on the system. But, the Treaty of Establishment basically says the Republic of Cyprus shall comprise the whole of the island of Cyprus. The Treaty of Guarantee, let's read that carefully again, remind ourselves of the Treaty of Guarantee. Greece, Turkey and the United Kingdom, taking note of the undertakings of the Republic of Cyprus, recognise and guarantee the independence, territorial integrity and security of the Republic of Cyprus. Greece, Turkey and the United Kingdom likewise undertake to prohibit any activity aimed at promoting, directly or indirectly, either union of Cyprus with any other state or partition of the island. And I emphasise those last four words. Now, the UK has gone on to reiterate its commitment to its obligation under the Treaty of Guarantee through a Memorandum of Understanding in June 2008. I won't read this out again, but it again mentions that the UK will comply with United Nations Security Council Resolution 541 and 550. And this has been going on for years. In the case of Kaglar in 1996, the Foreign and Commonwealth Office said that Her Majesty's government have not accorded, they filed an affidavit in support of the Republic of Cyprus. Her Majesty's government have not accorded any form of recognition to the so-called Turkish Republic of Northern Cyprus. Her Majesty's government recognised only one state on the island of Cyprus, the Republic of Cyprus, established under the Treaties of Guarantee and Establishment. I should make it clear that Her Majesty's government views with concern the suggestion that the TRNC should be held by the court to be a foreign state, notwithstanding that it is not recognised as such by Her Majesty's government. Again, I put all this up and summarise them on the basis that this is the background, this is what the United Government has had to say, the United Kingdom government has had to say. So why can't we protect our rights through legal means? Why shouldn't we protect our rights through legal means? Why are we frightened to protect our rights through legal means? Those are the questions I pose for discussion. It's meant to be a discussion tonight, so I'd like to be a bit provocative. As to the status of the so-called TRNC, some conclusions from what I've just said. The UK, of course, is bound under customary international law, from what I've just explained, not to recognise the TRNC. But why? Why is it bound not to recognise the TRNC? One, it does not meet the criteria of statehood under international law. Two, the situation in the north of Cyprus was brought about by use of force in flagrant violation of international law. So, it's pretty clear in my view what the position should be legally. The rule of law should be upheld. Let's look at some of the cases where the Cyprus issue has been through the English courts. Now obviously I'm going to start with the Apostolides case, but then I'm going to look at some other cases. Because what I want to deal with is the concern sometimes raised that do we want to take these risks? What if we do go through the English courts and we lose? The rule of law is in our favour. How can we lose? It's not me saying it. That's a hypothetical Cypriot citizen. When I talk about Cypriot citizen, I mean all the Cypriots, Turks, Armenians, Maronites and Greeks, because the rule of law applies to all of them. So when I talk about Cypriots, I mean all of them. So let's have a look. We've got a case study. We've got a very recent case, the Apostolides case. What did they argue? Now, lots of issues, of course, were argued, and eventually they were narrowed down to some main issues, some primary issues. The main issue that was argued before Mr. Justice Jack, where we lost, we being Mr. Apostolides, regarded the construction of Article 1.1 of Protocol 10 of the Act of Accession 2003. And I'm happy to say that we succeeded before the European Court of Justice, and we succeeded before the English Court of Appeal, and British Justice got it right. Why do I say that? Because what the other side argued was, obviously, this article, what it did was suspend the acquis in the occupied areas of Cyprus. Why was it suspended? Because the Republic of Cyprus is sovereign over the whole of the island, but it cannot uphold EU law as it is obliged to in the occupied areas. So the EU decided to enter into this transitory derogation from the accession of Cyprus to the EU. And transitory derogations are construed restrictively. You look at them carefully to establish what is their purpose. And the purpose of this derogation was because it was a narrow purpose. Cyprus is a sovereign state. We've just been through all the principles. It cannot comply with EU law in the occupied area. Why can it not comply with EU law in the occupied area? Because it is occupied illegally. Mr. Justice Jack got it completely wrong. The European Court of Justice got it right. The Court of Appeal followed the European Court of Justice. It should be construed narrowly and restrictively. The intention of the protocol was not to exclude the application of all provisions of community law with the bearing on areas in northern Cyprus. Now this case was obviously to do with the enforcement of a judgment, a Cyprus judgment, in favour of Mr. Apostolides. He can't enforce it in Cyprus. Why can't he enforce it? Because his land is an area which is occupied illegally by the Turkish army. So what can he do? Under the rule of law, under the rule of EU law, he is able to enforce his judgment in another member state. There are very, very narrow exceptions as to when he cannot, or when he is precluded from enforcing his judgments. One is on the grounds of public policy. Now this isn't the public, it's very important, this isn't the public policy of the government. This is a legal term. It's the public policy, a legal public policy, that's fundamental to the order of, in this case, the United Kingdom. The European Court of Justice looked at this and set out some criteria as to what is public policy in this scenario. And I can just read some of those. The court asked to recognise a judgment cannot refuse to do so on the ground that the law applied by the court of origin, i.e. Cyprus, is different from the law that it would have applied itself, i.e. English law. The whole point of this regulation, the regulation 44/2001, is to provide ease, the harmony between states, the principles that the EU is founded on. If you have a judgment in one state, you should be able to enforce it in another state. You shouldn't have to retry the case all over again. And basically, the European Court of Justice supported that. Recourse to public policy is permitted only where recognition would infringe a fundamental principle of the law of the state in which recognition is sought. So it's a fundamental principle in the United Kingdom is infringed. Well, actually, it was the opposite. It's true that the fundamental principle that should be supported is the enforcement of EU judgments. So the ECJ concluded that in the absence of such a principle, recognition cannot be refused on public policy grounds. So those are the two main arguments before the first instance court and the European Court of Justice. We then faced two other issues in the Court of Appeal. The primary issue, which was introduced for the first time by the EU Commission at the European Court of Justice stage, was a novel issue as to whether the recognition and enforcement of a Cyprus judgment, such a judgment, contravenes international public policy, since it may undermine efforts to secure a peaceful solution to the Cyprus issue. The Court of Appeal accepted there was an international consensus on the need to encourage a peaceful settlement, but then had to look at this issue and did so with great care and in great detail, and in my view, again, another example of upholding the rule of law, even to the extent that, and this is in the public domain, it's referred to in the judgment, the British Foreign Office wrote a letter, not formally intervening, but intervening in the case and putting forward its views. Whether or not that was a sensible thing to do, I'll leave you to surmise. Supporting the fact that, and I just summarise all the principles that the United Kingdom is bound by. And the United Kingdom, my government, wrote a letter basically saying, bear in mind the political situation. Effectively, we can't tell you what to do, but put aside for a moment the rule of law, put aside for a moment our obligations, put aside Mr. Apostolides' rights, and have a think. And what was wonderful about the case is I don't think the Court of Appeal was ecstatic about that, was overly impressed by that letter.
That's three judges, it's worth emphasising.
And three judges, that's right, three judges all agreed that it is not for the government of the day to tell the judiciary of the day how it should construe a legal issue and the rights of an individual. So let's just read through these, if you don't mind. So why wasn't this international public policy, this argument that let's not enforce this judgment because it may undermine the efforts to secure a peaceful solution to the Cyprus issue? Why wasn't that followed by the Court of Appeal? Well, the Court of Appeal said it's not manifestly contrary to public policy in the UK to enforce the obligation under community law to register judgments of courts in Cyprus. Remember where we are. Treaty of Guarantee, the 1960 Constitution. That's the law. That should be upheld. And that's the United Kingdom's obligations to be bound by that. And notwithstanding that, they felt they could write a letter intervening in the matter. The courts also said that it would be it had to determine whether it would be manifestly contrary to public policy to register and enforce a judgment. It would need to assess the issues in the Cypriot dispute, obviously, the merits of the political issues, both national and international, and the impact on public policy in the UK. Save in exceptional circumstances, this was not a function the court could or should perform. This was not a case where plain breaches of international law had been committed by the Republic of Cyprus, such that its laws ought not to be enforced in UK courts. It went on to say, a refusal to recognise the lawfully made judgment of a court in a lawfully constituted state, which is an EU member, would in fact inflame the situation. And this is telling, even if, and this is the core of the rule of law we've been discussing, this is the core of it, even if the UK government made it clear that its policy was to attach absolute priority to not prejudicing negotiations, because that's not in our perceived British interests, and that enforcing the Cypriot judgment would create such a prejudice, the court would nevertheless be required to follow the rule of law. Now, so, going back to the case study. At the moment, we've gone for Apostolides. The rule of law has been upheld. That's what's important about that case, in my view. And that's upholding the rule of law in relation to the rights of all Cypriot citizens of the Republic of Cyprus, whatever colour, race, or creed. Now, sometimes other cases are thrown at me. What about Apostolides? Didn't we lose that one? What about Polypec? Didn't we lose that one? We didn't lose them. They were decided on a principle of procedural law, which is called the Mozambique Rule. So we've got two cases. I'm not going to go into detail. I just want to give you a flavour. Polypec, all to do with enforcing property rights. At that time, I hasten to add, the law has moved on since then. At that time, and the Mozambique Rule basically says it's an English principle of procedural. It's a procedural principle of law. The English court has no jurisdiction to entertain an action for the determination of the title to or the right to the possession of any immovable situate or property out of England, i.e. foreign land, or the recovery of damages for trespass to such immovable property. So there, the issue concerned in Apostolides, the trespass, the conspiracy by Northern Cyprus travel agents in London conspiring to trespass in hotels in the occupied areas, the Dome Hotel, the hotel owned by Apostolides' family. And Lord Denning and the Lordships decided that the Mozambique Rule operated. That the English court, because the trespass and the conspiracy to trespass related to a foreign land, it wasn't for the English courts to decide on those issues under the applicable foreign law here, the Republic of Cyprus' law. However, we now have Article 22 of the EU Regulation 44/2001. My first point there, of course, is we didn't lose the case. Our rights were not diluted. The case turned on a point of procedural law. However, Article 22 of the EU regulation, now, in my view, as you've seen in Apostolides, if that case came along now, today, perhaps we wouldn't have such a similar decision. We'd have a different decision, because Article 22 says the courts of the member state in which immovable property is situated shall have exclusive jurisdiction, as happened in Apostolides. And the northern part of Cyprus is not a separate state under the regulation. So again, EU law is now assisting the Cypriot citizen to enforce his rights against trespassers in the English courts, as happened in Apostolides. The rule of law has been upheld and continues to be upheld. Polypec was similar. It was based on the Mozambique Rule. It involved, as on the Dias Polypec, which collapsed, as we all know, and the efforts by some Republic of Cyprus citizens to preserve their rights in relation to some of the funds collected by the administrator of Polypec, and to hold them under a trust. Unfortunately, the Mozambique Rule came into play there as well. I won't go through that. The other cases that we can mention is the Transport for London case. That was a case all about advertising Northern Cyprus on the London Tubes and on the Underground. That was the judicial review by the Turkish Cypriot travel agent and the TRNC, and effectively there, I have to add that decision was not appealed. It was based on the fact that the court decided that promoting holiday to Northern Cyprus wasn't illegal, primarily because the corporate entity, it felt, was exercising its rights under English law in England to promote holidays. It wasn't a recognition of the TRNC. Now that was a judicial review, and we are open obviously to judicially review any other decision in the future that may lead to adverts being issued in the United Kingdom. The final case is this case where we succeeded in preventing a Turkish operator, airline operator, from trying to succeed in judicially reviewing the decision of the aviation authorities in the United Kingdom to allow direct flights from the United Kingdom to the occupied areas of Cyprus. And we succeeded in that regard, where the court held that it was accepted in international law that the Republic of Cyprus had exclusive sovereignty over the airspace over all of Cyprus. And if the Secretary of State had granted permission, such permission would be in conflict with its rights. the Republic of Cyprus was capable of exercising its rights regardless of whether it controlled the territory in the north of the island of Cyprus. The court also asserted that the United Kingdom did not recognise governments, it recognises states. A legal duty existed whereby the UK government was obliged not to recognise the TRNC or its government. Now, I'm going to conclude with two more slides, before just concluding with some concluding remarks of my own. Another aspect of the Cyprus issue is this effort by the legal advisors to the TRNC, particularly Professor Stefan Talmon. And basically what they're trying to achieve is obviously, which is the holy grail for the TRNC, is legitimacy. As you all know, in Loizidu, the TRNC was described as a local subordinate administration. So it's accepted de facto as simply a group of people who administer births, marriages in that area. That's the only legitimacy it can have in international law. However, Professor Talmon, he appeared on behalf of the British Resident Society in the occupied areas. And his efforts, again, he appeared again for the Turkish airline, of course, in the Turkish airline case. And his submission was that the TRNC, being the de facto authority in northern Cyprus, was competent under customary international law to exercise prescriptive and enforcement jurisdiction in all matters under its effective control, including expropriating property, of course. The Court of Appeal dealt with a 40 or 50-page submission, I thought, pertinently in 3 lines, maybe 2 lines. Invoking customary international law notions of powers of de facto authorities does not, in this context, override or impinge either upon the legitimacy of the judgment of the European Court of Justice or the duties of the United Kingdom in relation to Article 34.1 of the regulation. Another slide I put up is a slide which Gliakos touched on this point, and we're all aware of this point because it came up in the Annan Plan. We're talking about the rights of the Cypriot citizens, the rights of the Republic of Cyprus, which are upheld and have been upheld in my personal view. But can those rights be taken away? Yes, they can possibly be taken away. Don't forget the Annan Plan. Article 5 of the Annan Plan stated that the common state and the component state shall, pursuant to Article 37 of the European Court of Human Rights, request the European Court of Human Rights to strike out any proceedings before it concerning affected property. Article 37 gives the European Court of Human Rights the power to strike out cases if it feels that this would be fair in view of all the circumstances of the case. So we've got to be vigilant. That was the position in 2004, which Lord Hannay thought was a perfectly reasonable way of stuffing the Cypriot citizens of the Republic of Cyprus, to put it mildly. Or another expression is a stitch up, but I wouldn't use that, of course. So I hope my case study has given you not a flavour, but a foundation that our rights are enshrined in law. They cannot be taken away. The only person that can take them away is us. I just want to end very simply by making that point. Yes, there are risks. I'm a lawyer. Of course there are risks going to court. I mentioned the judicial review in the adverts case. I didn't think that was the right judgment. I thought it was a very poor judgment. It wasn't appealed. Mr. Justice Jack got it wrong, but we appealed that judgment. We appealed it to the European Court of Justice. We appealed it to the Court of Appeal. If we hadn't appealed that judgment, we'd be lumbered with it. That doesn't mean the rule of law doesn't apply and will not be upheld. So, I will end at that point. I think I've hopefully provoked some discussion, which is my other objective of my talk, but I hopefully summarised my views on the simple question I started off with, which is, we're not going to solve the Cyprus issue. And I think that misses the point. We're not going to solve the Cyprus issue through the courts. And I believe that misses the point about the rule of law and enforcing our rights. And I think it misses it Not by a square mile, a lot more than that. Thank you.